So, welcome everybody. I'll call the meeting to order at 1 o'clock, and we have the agenda additions and approval. Is there any agenda additions from anybody of the staff? Any from the board? Seeing none, can I get the motion to approve the agenda?
Move the agenda be approved.
Board member, Mr. McKay. All those in favor? That is carried. Do quick introductions right now. And we're going to start with Marlene.
Ernie Gender, board member.
Paul McKay, board member.
Larry Clark, board member.
Dave Grover, board member.
Justin Stevens, board member.
James Nyberg, board member, MPC chair.
Rick Teal, director, Parkland Community Planning Services.
Tricia, Director of Municipal Services.
Michelle Hoover, Legislative Assistant.
Linda Donovan, Director of Planning Services.
And back into the corner.
Barry Green, resident.
Yeah.
Robin Potter, Bylaw Officer.
Rich Fitzgerald, development officer.
Judy Strum, resident. Barry Strum.
Thank you. Welcome, everyone. And the minutes approval, did anybody get a chance and opportunity to read them that wants to put it forward? Mr. Clark, any questions or concerns from the board? Seeing none, call the question. All those in favor? Carried. No business arising from the minutes. What we'll do right now, if you're okay with this, Jacinta, is we have a couple of people within the chamber. So what we'll do is ask for, in order, who's the first up? Will it be 6.3?
Yes, it is.
Okay, so let's deal with, if the board is okay with that, I see a nodding of heads, yes, then we will go ahead and take this one first. So go ahead, who's taking it? Okay.
Thank you. So this application was presented to the board in September at our September meeting. And the request at that time was to reduce the front yard setback from 10 feet to 3 feet. The board requested that the setback be brought back to the original approval of 10 feet, which was approved at a previous meeting in March from 25 feet to 10 feet. Also, we have a revised site plan which shows a second approach off of McDonald Drive. So that is what's on your screen. As well, the applicant has obtained a slope assessment report from Parkland Geotechnical. And the new site plan does show the setback from McDonald Drive to 10 feet.
So page 26 of our package for anybody that's trying to find it still.
Also,
Okay, sorry, go ahead, Jacinta.
Also wanted to mention the tree coverage, which we've been discussing with the applicant. So the land use bylaw defines the tree coverage as the total tree area of the lot before any development. So with the garage, there will be a few trees that will be removed. So that would bring the coverage down to 780 square meters. So an 18% variance, more or less, is required to reduce the tree coverage from 920 meters to 780 square meters. And that's just an estimate based on an aerial sketch of the property.
Okay. Anything else?
All I believe we have, unless the applicant has anything that you would like to add.
Okay. Mr. Green, do you have anything?
Other than any trees that were removed that didn't have to be for the construction are going to be replanted.
Fair enough. Okay. Mr. Stevens.
I have a question, page 27. It's 3.1.2. The location of the buildings must meet the minimum setback requirements. And it says front for an ancillary building is 3 feet.
Yes, that was an error. It should be 10 feet.
Okay.
And it does say above, but yeah, Mr. Green had pointed out as well. Sorry, I had to bring that correction forward, but that will be changed to 10 feet.
Okay. So 10 feet is the rule now?
Well, the 25 feet is the original the minimum setback in the land use bylaw. And at the March meeting, the setback was reduced to 10 feet. So this is, the proposal today is for 10 feet from the front property boundary.
I guess my question through to administration is, why are we even seeing this if it's already been approved?
Because of the revised site plan, which shows, we had presented an alternative site plan with 3 feet at the September meeting. And then the site plan was revised to provide for a second approach.
Okay. So basically what we're doing is, in this, it's not the setback we're looking at, it's the approach and the trees that we're basically deciding on, right?
Yes, and
Because we've already previously said he's okay with 10 feet.
yes.
Are there any questions of Mr. Gender?
I had some concern is what Mr. Stevens had, but on the drawing, it does show the 10 feet, so there was conflicting with it. It's good to see it verified. Thank you.
Mr. Stevens?
Question for administration. Public Works, have they seen the second approach? They were satisfied?
Yes, there is a report on page 31 that was provided by the operations department on what needs to be done to provide for that second approach off McDonald Drive.
And Mr. Green, you're okay with that? There's nothing out there that jumps out of you?
Yes.
Go ahead.
Well, I will put forward the motion that we approve with the conditions laid out at the 10-foot mark with the second approach.
And also, if I can, and also with the variance of the trees being removed. Okay. So just so everybody knows what we're voting on is that make sure that we have the 10-foot. We've already approved it, but just make sure that it is in place. There is a variance of 18% of tree removal, and then the approval of the second approach.
And initially I was concerned about that second approach, but it is a very limited traffic area at the end of a dead end. So there's very minimal traffic that has to go beyond this.
Okay. Is there any other questions, concerns? I see shaking of heads, no. Okay, all those in favor? That is carried. Mr. Green, it's been a very long, drawn-out process. I apologize, but sometimes we do run into those.
No, that's partially my fault.
Thank you for your patience with us.
Yeah, thank you.
Okay, I guess you can go build a garage now, right?
Thanks.
All right, 7.2, I think is our next one, correct? And who's taking that?
Hello, Mr. Chairman.
Mr. Teal. Go ahead then. Page 75 of your package for people that want to follow along.
I will do a brief run down, Mr. Chair, and I would ask that the applicants do have a few words they'd like to speak about before the board or commission makes a decision. So the application, if I can ask Andrew to go to the right page for you, sorry. Probably the best is to start on page 62 of the package. Thank you. So this application is to create a farmstead out of a very large parcel. It's bigger in a quarter section. It adds some of the land to the west of it that was isolated from the other quarter section, separated by the creek. So that's why you see a different parcel configuration than you're normally used to seeing. In the pink, it shows an approximately 21-acre block of land. And one of the unique aspects of this property is that it was part of an overall farmyard drainage, I believe is the name of the program, that basically looked at the very flat nature of this area and did a substantial amount of regrading to deal with runoff and issues to make it more viable for agricultural production. That applied across the acreage or the farmstead being created and also the balance of the quarter section. So that's one of the considerations the applicant has asked us to take into account as we look at the size of the parcel and the boundaries that they've chosen to encompass. So the area that you see does meet certainly the LEV's minimum requirement of 3 acres, but it's going quite beyond what we usually try to encourage is the smallest amount of land necessary to be taken out of the block of land. And largely the reason for that is twofold. One is the capturing the corrals and space, which really sets the north-south dimension, which also would address the issue of open discharge on the property, which is another topic I'll come to. But then as you look farther to the east, there's a substantial amount of land that's been added past a fence to try and capture a key drainage point that serves the acreage and gets into a wetland there. You see in the treat area, the middle part of the quarter section, that serves as a depository for all that runoff from the proposed farmstead. It also picks up drainage off the range road, or sorry, the township road on the north ditch. There's a low-lying spot where that relief goes right across that east area and into that reserve, that wetland area. The application itself meets the MDP requirements in terms of statutory, what we expect to see in the agricultural area. Again, as I mentioned, the weakness is that it's a little bit bigger given that drainage program and considerations. It doesn't have any issues with road dedication. That's already been taken care of as part of the previous subdivision on both the south side and the east side. The open discharge system that's in place right now, does not meet the requirements. I'm not sure if we have that as one. I don't think we included it. There it is. And predominantly that's along the existing property line that's along Township Road 40-4. So there is space, just by virtue of capturing the corrals to the north, to relocate that to be able to make the discharge point, to be able to meet the requirements for setbacks from all the property boundaries and the building. The recommendation is for approval, subject to a small series of conditions that you can see attached on, if I can get Andrew to jump back to page 60, please, in terms of the text. And I won't go through the sort of page 60 of the PDF here. Okay, there, thank you.
You're working on a different program. Page 75, where are you trying to get to? We're 75.
82.
Yeah. Page 80, isn't it?
Yeah.
Yes, we're on the right page, Mr. Chair.
There we go. So,
The first three are pretty standard. They have to have a surveyor bring in a drawing. They do have to settle up the property tax. It's just like a real estate transaction. They do have to put on a new address sign if need be. And then the bigger condition is about condition number 4, and there's some options for the applicant. They can relocate the discharge point, which you can see on that previous drawing. There is space to be able to accommodate that, and then indicate that on their surveyed plan that meets the property setbacks. Or the second part of that is replace and upgrade with a new system that has lesser setbacks. But however, given the groundwater conditions in that area, it's highly unlikely, other than a pump out tank, which would be more expensive than the open discharge, that would occur. I do want to speak specifically to the issue of the Rural Development Fund. There is no set policy or scenario that's laid out nicely in writing for staff to interpret this. So it is somewhat of a unique situation in that regard. 5 acres that I mentioned earlier that covers that drainage course would mean about a $5,000 contribution to the Rural Development Fund. As you can see laid out, the exact numbers are in the report. Mr. Chair, the applicant does wish to speak to us about a few items, I believe, in terms of the drainage and also the open discharge and the status of the existing system.
You betcha. Go ahead, Mr. Strong or Mrs.
we
Strong.
have speak to the podium, perhaps? First of all, folks,
Just go, if you could go to the mic too.
it's on. It's just-
We were just talking about how councilors
Test.
are hearing.
Hi, first of all, folks, I apologize. I've lost so much of my hearing to motors and stuff like that, so please speak up to me. And I haven't had a chance to get into hearing aids yet, so. But I didn't, first of all, we didn't get Greg's report until we just sat down. Second of all, I guess there's a couple ways I'd like to view this with the county. According to our research, it's an open face discharge, and it's been there since the 1950s. According to our research with Jerry Bond, that's with IGJD, pardon me, the boundary to the existing right-of-way with the county is within distance. Second of all, with that discharge being there, it's out of the way presently for the existing site and for the acreage. It's just the ideal place for it. Can't go no place. In fact, in the spring, a little bit of the county water runs into it and it handles it. Now, that's our request, is to leave it there because it's just perfect to the situation. According to our understanding with measurements, and this is our understanding, it meets all the measurements to the county line and to whatever. And according to Jerry Bond, because it was put in so early, and to what I'm gathering from information, I'm hoping it can be grandfathered in. Now, if we go to the east side of the acreage, if we go to the east side of the acreage, when we come to that place, we had a certain amount of areas in the yard that held water, and we went under the environmentally friendly program and drained it. Now, with saying that, the county water comes into the east side of that 5.25 acres. With also saying that, it helps the drainage in the yard on the east side. Now, we can incorporate it into the acreage or we can exclude it. And I would very much like it incorporated because it protects the water drainage from the county and the water drainage from the yard. Now, the ditch is a slow ditch, and we knew that when we put it in. McNabb surveyed it in the whole 9 yards, but it does handle the water over a period of time. Now, I'm under county advisement, and with saying that, I would like to have some reprieve on those acres if we could include it. And I'm not asking no reprieve for any other acres, but just what's involved with the drainage there for the yard and the county. Now, with saying that, our concerns are, to verify these numbers and measurements, we had a real property report done by Bob Milchke, a registered surveyor. So what you guys see isn't our figures, it's a true surveying figure. And I guess these are our requests, our biggest requests. Now, pardon me, but we don't want all the workload anymore. We want to either subdivide the acreage and stay there, have the opportunity 2 ways, stay there, or see if we wanted to sell it later on. And we want to get rid of the farmland and the cattle. We just don't want the workload. So this is why we're proposing to do that, for 2 options, to drop our workload and for the option to stay or sell it. And that's why we're proposing it this way, so.
Okay, absolutely. Can I just get clarification, Craig? With the setbacks, is there a grandfather in that, or?
Mr. Chair, the applicant has been in touch with IJD.
Yeah.
And they have sent in a letter. That is something that I would probably have to follow up with them to confirm. That's not our read of the provincial regulations, but they are more familiar with them. And I'm also, it's a 1-page letter. It doesn't necessarily show how they drew their conclusions. So that'd be my other follow-up question for the safety codes officer is signing off on this. In your package, you can see the survey drawing that Mr. Strom has referred to that shows the open discharge location and also shows the drainage he was mentioning. Nonetheless, if the committees are willing to accept it, that there may be a possibility of a grandfathering on that, we could modify condition 4 to add an item for C to allow for that eventuality with something along the lines of the full weight will fall on the inspector signing off. That this meets the private sewage disposal system, and they'd be advised to attach a map on what material they're using to draw that conclusion. So that would be an option available to the board to modify and add item C. But the other item I would like to speak to, Mr. Chair, if I may, Mr. Strom's request for consideration on the drainage is specific, if I understand. He'll correct me on this. Mr. Strom's request on the drainage aspect is specific to the Rural Development Fund. So he would like to keep the 5 acres that's on the east, but recognizing that there's drainage going down there, he would like some consideration on whether or not the full $1,000 per acre would apply to him in that particular case. And my advice to the board, if there is a willingness to give them that kind of consideration, then we need to have a fifth condition that says we'll do that, but it'll be in exchange for a drainage easement, so that we don't have to deal with this for another property owner at a future date. So the water from the ditch could continue to cross the new parcel and then reach the balance, and possibly even covering the wetland that's being the final outlet and receiver of that water.
Okay. I'll be honest, Mr. Strome, I would do it if it was me. You went through a lot of work, but I would hook up a hose, discharge it to the north, then somebody look at it and disconnect the hose, but that's me. So I don't see that as a big issue. I'm not sure about anybody else on the board here. I have absolutely no issue with that. I also concur with Mr. Teal that we forgo the 5,000 on the other drainage area, because I see that as a benefit to the county. I do believe, like Mr. Teal says, that it should be something that should be put maybe a little bit more firm in writing, that if this current owner doesn't own it but sells it to another person, that we don't lose that benefit, I guess. And Mr. Stevens, I'd just like to hear your point. Any thoughts?
Pardon me, Mr. Stevens, can I make a comment here?
Yeah, go ahead.
Please proceed. We hadn't got Drake's report till just sitting down here. Now, we're saying that, I'm not trying to cause a rip between Greg and ourselves, but if we had that report earlier, we could have brought this to the intention of Greg, so this isn't becoming.
It is. I don't see this as a problem.
Okay.
Yeah, no, I think we'll get their opinion and see where we're at.
Thank you.
Mr. Stevens?
I would be curious about the septic discharge, and I mean, if this is approved by a accredited professional, then I'm not willing to say otherwise. I don't want to overrule that. So I'm definitely open to that condition. As far as the drainage, I better carry on. I'm still formulating my thoughts. But
Okay, Mr. Grover, what's your thoughts?
That looks all right to me.
Okay, Mr. Grover, or Mr. Clark?
Yes, when I see this and see it as part of a grant for a farm improvement, I do agree. We need to make sure that there's easements there to maintain that through the next property owner though too. And the only thing to confirm on the sewer would be the issue that if the property was to sell, is it going to pass the second time, or is it because the owners are there? Like that would be.
No, that's fine.
Would that sewer still be legal?
Okay,
I'm all in favor of it, including the grandfathering, if it's okay to grandfather it in, right under those conditions.
Mr. Gender?
I find that like with the pump out on the sewage, like there's an extreme amount of sand that's on surface, whether you pump it out there or whether you have to move it, it's going to very much be contained within that sand area. And being that if it was say like another property that was on the road allowance, it would be a different one where you could possibly put a residence. But I look at the way of the road allowance plus that, you're going to be well away from any adjoining. But I have no problems with it at all.
Okay, so Craig, going forward as far as conditions that we put in, we're okay with the 5 acres. There seems to be no issues with that as long as we get some sort of drainage agreement that goes forward. So that would 5C, you said that was going to be?
I think that would be number 5, Mr. Chair.
Okay, number 5.
So, again, I'll give maybe a general wording if you don't mind with this.
Yeah.
For sure.
Something along the lines of provision of a drainage right-of-way for the county's purposes to the satisfaction of the county in lieu of contribution to the Rural Development Fund, so that we have a bit of a record. In terms of the actual, so that I'll try to refresh that or rephrase that so Marlene stands a chance to know where I'm going with the general gist. Again, it would be provision of a drainage easement to the satisfaction of the county for the county's purposes of draining range or Township Road 40-4 to in lieu of a contribution to the Rural Development Fund. In lieu, I think we may as a group be talk about the $5,000.
Right.
In terms of the specific follow-up on that, I would help to work with the Stroms to deal with the wording of the actual easement agreement that would actually apply in that particular circumstance.
Okay, and then the board is okay with that? Okay, I see shaking of heads.
Are we,
And then now the sewer issue. Go ahead, Mr.
are
Steve.
we looking at registering a caveat on?
So the drainage easements, either if we create a pure run with the land, we don't have to use a caveat. But yes, there would be a note on title, which I believe goes back to one of the other points I heard over here in terms of having a flag for both the current owner, future owners of both the parcel, where the drainage is cutting across, but also where it's stopping the balance of the quarter section, making sure both of those privileges are covered. And we can do that so long as we're still dealing with the same property owner before we split it. So both titles will most likely end up. The caveat is a comfortable one for me to say yes. That's kind of the backup. But sometimes drainage easements, if they're a pure run with a land agreement, they just show up on their own. You can register it that way.
And we have a number, at Carlisle Estates, it comes to mind in my area that we do that's where it was happened, goes on to the private property. Now, for the sewer situation and discharge, what's your proposal? Craig, you're stating that we could simply accept the IGB report, but that's a little bit, it's a one-page report, not really as official as it would. But you're saying that there's a possibility of the condition being changing, which one?
Mr. Chair, so this would be an addition and it would become 4C. And on the likelihood that there is a grandfathering option and the professional is prepared to sign off on it, it would be confirmation from a accredited safety codes officer that the current open discharge system meets the requirements of the private sewage disposal systems regulation, quote, 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 quote. And that confirmation of that be provided in writing to the county satisfaction.
Okay, so 4C would be a condition that we would put on there. Is that something, basically just saying somebody else is saying it's okay to go? Okay, so I see again nodding of heads. Okay, so I'd like a motion to go forward with that.
I'll make that motion to go forward with the approval of it with the recommendation.
The two changes to
Yes.
the
Recommendation, yeah.
Marlene, I know when you get frustrated with us, your eyebrows get. Are you okay over there, dear?
I can't be okay.
All right, we're wordsmithing with Mr. Teal and you guys will come up with a plan. Okay, everybody on the board has an understanding what we're doing. We are going to, in essence, give up the acres rural contribution fund for basically allowing us to pour some water on there, and the sewer, as long as somebody else signs off, we're good. Everything else stays the same. I will call the question. All those in favor? Mr. Strom, do you understand what we're doing there then?
Yeah, Mr. Nyborg.
Yeah.
Thank you. Yeah, I guess I'm sorry.
Yeah, there's everybody else in the world listening to you, so.
I'm sorry, guys, and ladies. Yeah, I understand that yous are giving us the acreage to add on because of the drainage. I think that's very important because at one time, when we come there, it was all alkali, and definitely it's going to affect the yard and the county road in the long run. Now, just telling a little bit of story about it, because the drainage, as you see, is so slow, one plow or some erosion is just going to stop it. So yeah, it's a great value to the acreage, and I appreciate that. Now, I couldn't understand it all with the pump out, but to my experience, and there again, I haven't had a chance to review this with Greg, but to my experience with Action Plumbing, JID, they can grandfather this in, and Jerry Bond that looks after the area signed it off. So I guess this is where we're coming from to try and leave it in place because it's very environmentally friendly to the yard.
And that's where we're at. You can do that just as long as you provide us the information they gave you. We're good.
Okay, thank you.
Yeah, absolutely. Yeah, for sure.
Part of my hearing.
No, that's cool. We're all there.
And you'll just work with Craig on that also.
Yeah, absolutely.
Thank you.
Okay, you're good?
I'm very good. Thank you all.
You betcha. Okay. We will go back to development officers report. So I'm taking this as this is your last one.
It is, yes.
There you go.
Thank
Make it a
you.
good one.
Yeah, well,
As usual.
it's a little quieter than it has been the last few months, so things are kind of slowing down. So for last year, 2021, we had processed 131 permits up until the October 26th. And at this year, we're at 107. As far as our subdivisions, we had 23 at this time last year, and we're at 12. So we're just half. And so we're catching up slowly, but probably not going to reach the numbers we had last year. As far as what we've been up to the last month, well, meetings, some site inspections. Our bylaw officer toured the ER with the president of the Roshan Sands Heights Community Association to provide their report for the application coming forward today for the dock and lift storage on the ER. We've met with residents regarding subdivisions and future development permits. And that is basically what we've been up to for the past month. So it's been a busy month, but it is slowing down, heading towards the fall. So thank you.
There you go. Okay. Are there any questions for Jacinta's development report? If not, can I get a mover? Mr. Clark? All those in favor? That is carried. So on to development permits 6.1. Is Craig taking this one or who's taking it? Oh, there we go.
Fitzgerald.
Thank you, Mr. Chairman. The applicant is proposing to construct a 2,645 square foot detached dwelling with an attached garage and an oversized ancillary building, 2,520 square feet, to be used as a workshop and storage. The applicant is also proposing to use a 40-foot C-can for additional storage, which is a discretionary use in a multi-lot subdivision. The ancillary building, oversized, is also a discretionary use in the country residence agricultural district. The proposed development exceeds all the setbacks as set out in the country residential agricultural district in the county land use bylaw. Water will be provided by an on-site cistern and water being hauled in. Wastewater will be handled by an on-site septic tank and leach field, not an open discharge. Access is provided via a county road named Trust Court, but there is no existing approach to the property that meets the county standard. So a condition has been added that this will be a requirement of the permit. The proposed location of the approach has clear sight lines in all directions. The applicant is also proposing to use an RV as a dwelling unit during the construction stage and only until the dwelling is finished. When proposing to build such a large ancillary building, we did ask the applicant at the time what the proposed use was going to be. And eventually they're looking at opening up a greenhouse and using it for storage in a workshop at that time, but that is not part of this current application. That concludes my report.
Okay, thank you. Yes, my concern, and then when I see a large oversized shop like this, what's the chance of it becoming a dwelling unit? We see this so often where somebody puts it up and then they move in and live in it. So.
The drawings were provided for the house that they're looking to construct, and it's it's a large house. I'm guessing the cost of construction is probably going to be in the $500,000 range. So,
did they take the permit out for it already?
It's part of this one as well.
So this is the both, okay.
So if it would have been just the house that they were applying for, that would have been a permitted use. But because of the oversized ancillary building and the C-can for storage, that's what brought it. So all three developments are part of the same application, but the house part of it would have been a permitted use.
And we wouldn't have seen that. Okay, so we're only seeing this for that because of the oversized shop.
And the C-can.
Oh, yes, the C-cans. Okay, Mr. Gender.
On this one here, like they're saying that there's no approach on it. Is the county going to be building the approach over there?
No, it's up to them to cover the cost of the approach construction.
Like, by the looks of it, there doesn't appear to be any ditch really in there.
Not really, no. So generally what we would do in a situation like this is the requirement would be for them to peel the topsoil off down to about 200 to 300 mils, pack the clay, and then haul in some crushed gravel and compact it so that the water drains away from the road and not, so they're not draining their property out onto the road. So it should be at about a 1 to 2% grade away from the road edge onto their property, to the property line, and then they can do what they want from the property line in. But I can't imagine that a requirement would be to install a culvert.
Nowhere to install a culvert.
Right.
So with that, I'd like to move it ahead, please. Staff recommendations.
Okay. Okay, with the conditions that are put forward.
Yes.
Okay. Okay. What's on the back side of this? I see some pictures on the back side. I'm looking on page 16. What is that berm back there?
That is I'd say it's overburden. Actually, the gentleman that used to own this property owned the property next to it. And that was, I think the county was building a road, and that was the clay that they had hauled in. And they kind of built a berm out of it. And I think what his intention was he knew he was going to sell this property at some point, and he wanted a kind of a buffer, a view buffer between his property and this one. So it's just, honestly, just an overburdened pile of clay.
Okay, so no facility or anything there. Okay. We have a go ahead, Mr.
So this berm is on the adjoining property?
No, it's on his side of the property line.
The only concern I have with that is, okay, like, in order to build it, it's gonna be weed infested eventually in time.
It's been there for about 10 years, and it looks like they mow it. There weren't any weeds there that day, and they mow it the same as they do their lawn.
From the pictures, that's what it looks like to me. Go ahead, Mr.
Just wondering if Mr. Gender is open to another condition. When we've allowed C-cans in the recent past, it's always been adding a condition that administration approves the aesthetics of it, because some of these can get pretty degraded, and we're playing with a gray area. At least if it's in new or reasonable condition, then we have some protection.
By the pictures, it looks pretty good.
You don't want a pink C-can.
Well, if that's the one they're keeping there, I think we're all right, but
It's a valid point. Is there not a limitation on our C-cans, or what do we do?
I think that's why it's a discretionary use, because that gives you the ability to look at it and add any conditions that you wish.
I'll be honest, Mr. Stevens, I'm looking at this, if he's putting up a $600,000 house, I am kind of leaning to the point that he's probably not going to, or someone in the household.
May not allow a dirty old C-can in the backyard, just saying.
Perfect. I suspect he won't have an issue with the condition.
Absolutely. Absolutely. Yeah, that's right. So, through to administration, the condition on the C-can that it stays in a sightly condition. Okay, does that work for you? And I'm not sure where you want to put that as under condition.
$11? Is that fair enough? Work for you, Mr. Fitzgerald? Okay. Works for you, Mr. Stevens?
Works for you, Mr. Gender?
You betcha. Thank you.
Now, is there any other questions, concerns? Seeing none, I'll call the question. All those in favor? That is carried. That's got to help the development process. Okay. 6.2.
Ocean Sands Heights Community Association. Who's taking this one?
I am, thank you, Mr. Chairman.
Okay.
So this application is to provide for private storage of boat lifts and docks on the environmental reserve at Ocean Sands Heights subdivision. The Municipal Planning Commission approved the permit last August to provide for the storage on the ER for a 1-year period. It was a trial period, and that permit expired on September the 1st. A condition of the permit stipulated that no private encroachments or any encroachments were permitted on the ER. So our bylaw officer, along with the president of the community association, toured the ER and did find a few encroachments. They were minor, and they will be addressed by contacting the applicant and asking that they address the issue there. So the association has established a database where they, and I've provided a copy of with the private information removed, that records all the information, proof of the $2 million liability insurance, the contact information that is related to a tag that's placed on the item. So they're able to track the items that are stored by a tag on the spreadsheet with the information for that landowner. So last year we had about 25 items that were stored, or not items, some owners have more than one item, but 25 landowners that had applied for the program. And this year we have approximately 18 that will be storing their items. And then we have the definition for private storage and docks, which does allow this, the liability insurance. And so there were some pictures attached to that on page, I'll just scroll down, that were taken. On page 23, you have the list of the how they're recording and tracking the information. And then on the following page, some photos of the items that are currently stored, as well as some items that are, the footprint is more than what we would prefer. So we're going to ask the landowners if they could reduce that footprint by dismantling the docks and stack them like some of the others have you seen above. And I don't think there's anything else. Robin was able to assist with that, and she's taken these photos. And
Robin, do you have any comment on it? What's your thought? Did it work, I guess, Jacinto or Robin, either one? What are your feelings on it? Staff's feelings?
I thought
Hold the flags, that's okay.
I thought that the program was very well organized. Jason Delwu has done a great job organizing it and talking with the other landowners. From what I saw, most of the docks and lifts that were stored on the ER were well placed in areas that wouldn't cause any damage. There was a couple of docks that you see on this page here that were pretty long, 5 or 6 pieces in length, that I did ask him to talk to those landowners to break them down just to make a smaller footprint on the ER. And he didn't see any issues with that. Besides that, it looked really good down there.
Just a question on that is for this permit. We gave them a 1 year. Is there a term to this we review it every year?
That's what I would see on this. And then going forward, if they apply for longer, that might be it. But this is still new to us. That's my interpretation of it, that we would go another year and go down that route.
Especially with the 25 to 18, you kind of wonder maybe there's some that aren't signing into the program too.
Well, from what we've understood, and there are some photos as well that we were taken of the items being placed on private land. So if they have the space on their property to move it onto the private land, rather than submit this to the program, they relocated it to private land.
There was quite a few houses or landowners that were able to push all of their stuff into their backyards.
Mr. Stevens?
Of note, there is several people that have listed docks or lifts for sale because they have purchased into the marina. So I'm in favor of keeping this short term, that 1 year, because I suspect our numbers are going to be somewhat fluid for the next year or two.
Fair enough. That being said, I need a motion to move forward with it.
I will give you a motion that we accept with staff conditions.
Okay. Any questions, concerns coming from the board members? I'll call the question. All those in favor? That is carried. Done, Mr. Green. So 6.4, who's got the Shermans?
I do, thank you, Mr. Chairman. So this development permit there was a development permit issued by the development officer on July the 4th to provide for the use of a JACO recreational vehicle on lot 15, block 2, plan 0620307 within the Roshan Sands Heights subdivision. The development permit was approved subject to a condition that the 1993 JACO be removed from the property by September the 30th. Pursuant to section 76(4)B of the land use bylaw, an RV shall be no more than 15 years at the time of applying for a development permit. At the September 28, 2022 Municipal Planning Commission meeting, the board members considered a request from the landowner of the subject property to allow the 1993 JACO to remain on the property until the permit expiration date of June the 14th, 2024. The board determined that revisions to the existing development permit could not be entertained as a new application would be required to revise the existing conditions. So we have received a new application. This is what is before you today. We've had several conditions added with the expiration date to remain as June the 15th, 2024, and the JACO, 1993 JACO to remain until that time.
So it seems to me that we had this before, but we couldn't change or substantially change the development permit after it's done. That was the issue that we had last time, correct?
Yes, and it had been referred because it's a discretionary use, which our development officer can approve, but it's still discretionary, which means it needs to be referred to adjacent landowners. So that referral had been done with the condition that our JACO be removed by September. So for changing that, we'll need to do a new referral stating that JACO would remain until 2024.
Okay, but I thought, and maybe I was having some confusion on this, but the reason we didn't do anything last time was because we couldn't substantially change that development permit that was in place. So they are canceling that and doing a new one for a 7-month.
This is a new application. It's more than 7 months. It's just that the existing permit that they have, the RV was supposed to be removed by September 30th, 2022. It had to be removed by the end of September. But with this proposed change, they would be allowed to leave the RV there until June 15th, 2024. So it gives them an additional 2 years to leave the RV on the site. And there is a submission by the landowner stating the reasons that they would like to leave the RV on the site until 2024. They're considering the construction of a home on the site, and they do not want to purchase a new RV as a temporary dwelling.
They better buy a new home right now, because I'll tell you what, it'll take them that long to get it built.
What say the board? You can't just sit there. Say something. Mr. Stevens, Mr. Clark. Go ahead, Mr. Stevens.
In a temporary situation, I'm willing to entertain it, but I would like to point out that if we don't, then we're circling back to additional issues. Because I believe the deck and lean-to and everything that was built on, if we don't approve the RV, then that ancillary use would no longer be allowed. And we're gonna get into a snowball effect on this one. In the interim, I would be willing to extend this permit. It looks like it's in reasonable condition, the unit itself. Not my color preference, but I'm not a homeowners association, so temporary, I would be willing to move this forward.
Mr. Clark.
I'm just concerned that temporary, this 2-year temporary is gonna lead to another temporary, that's gonna lead to another temporary, so it's just.
Have we had an extension on this already?
No, but we've issued it in previous year. It's just over to 15 years. So it was a 2-year permit. It's over 15 years. This is the first time we've extended it beyond, it would be 20 year, it would be over 20 years by the time for renewal.
And I think that's one of the reasons that we do this, is that it becomes that we get to have a look at it and see what is visually inspect it, basically, to say that we're okay with them going forward with this. Is there a stipulation that we could put in that they have to have a development permit in place for a new house within I mean, if they come, here's where I see they coming into us on September or in June of 24 and say, I need to keep it for 2 more years because I'm building a house. I don't know. I'm a little tough on that one. I'm gonna go with Mr. Grover and then Mr. Clark.
I'm gonna vote against it.
Thank you for letting us know. Mr. Clark.
I just look at the houses behind and stuff, and I think part of these areas that we're setting up, we need to honor what the intent of the areas were. We got to get to that point eventually, because there's a house, you can see the houses behind it.
So through to staff, this is a new application. We can change it, right? Substantially change it to June 15th of 2023, which would give them 7 months.
Come back with a game plan.
Come back with a game plan, because I see this coming back in 24 and it being an issue. So that is something that can be set out. Seeing that as Mr. Stevens.
I'm not sure if we can add the condition that they have to apply for a detached dwelling, as they've indicated in their letter by the end of the term. Is that?
Yeah. No, I don't necessarily, it could be a condition of that the permit runs out by that time or whatever, but no. This is the fix on that, I think, is changing the date stamp on it. Mr. Teal or Mr. Fitzgerald, somebody was waving at me over there.
Let me shake my head, Mr. Chair. So no, you can't attach a condition that presupposes a future application that you haven't even seen.
Could table this application and maybe suggest to them that they bring an application forward for the house. That would give them a year to start construction. A part of that application could be to use this RV as a dwelling unit until such time as the house was done. So that would give them a year before they would have to start construction, and 2 years to complete.
I think that's a very valid idea, but I think also making this application to 2023 would also send the same message that we need to see something happen. But that's my one person. I don't know what the board's feeling is on that. I'm hesitant to give them almost 2 more years of this, basically 20 months or whatever of time, and then they come in with an application, and then it'll be 2 years dwelling unit with the building of the house. So that puts them into 4 years of still having the neighbors see this property. Go ahead, Jacinta.
Just, you could, at the time they apply for a development permit, not allow the RV to remain, if
But yeah,
that's.
but that would be a decision we would make at that point.
Good. Well, I guess I'll get the ball rolling and put a motion on the table. I would be willing to make the motion that we approve this RV permit for till it ran out on September 30th. So we will approve it for 1 year essentially till September 30th. That gives them 1 season to use this. We're not gonna continue to kick this can down the road. We bought them some time to make alternative plans, and we're only approving it for a single year. That will be my motion.
Okay, I have a motion on the table. Is there any discussion from the board? I'm not seeing anybody jumping up to make any discussion, so then I will call the question. All those in favor? And those opposed? One opposed, Mr. Grover. Did you get that, Marlene? Okay, so September, what's your date in September?
September 30th.
Okay, fair enough. Of 2023.
Correct.
Just for clarification for Marlene. Okay, moving on. 7.1. Is that where we're at? Who's taking this one?
That will be me, Mr. Chairman.
Oh, right on.
Torture Andrew again with the wrong page numbers. We could bring up, let's start on
We've got page 42 of the package.
54, please, if we could start on.
54 is where we're going to, everybody?
Just a little bit of a context. So just so you know, this parcel is directly south of the former village of Botha, so now the hamlet of Botha. It is directly on Highway 850, so there's no county roads at stake in this. And I wanted to start with this one because immediately north of the hatched area that you see showing the parent quarter section that the pink parcel is to come out of, there's a triangular block of land, and that is a waste transfer site, former non-operating landfill. So that is probably one of the wrinkles for this particular application, why it's taken this long to process, was the proposed parcel is within 300 meters distance of the waste transfer site, former landfill, which required Alberta Environment and Parks relaxation of the 300-meter distance, which we only recently received in writing, and just lucky to slip under the wire in terms of a change in regulation, where any other future requests like this now coming forward will not be decided by AEP. That has been downloaded onto the municipality and to the applicants, subject to them doing the sufficient engineering requirements that AEP themselves theoretically would have done, which means it'll be tens of thousands of dollars of studies to do these kind of setbacks in the future. So for the applicant in this particular case, they're fortunate that this is kind of one of the last few ones to make it through the gate and benefit from the transition clauses, that change in regulation. Yeah, can we jump to page 57, please, Andrew? So the nature of the application is to create the first, well, it would be the first parcel out, but unfortunately another triangular piece had already been taken out of this parcel. So technically it's a second block of land to come out of the unsubdivided quarter section. Up in the northwest corner around the existing farmstead buildings, and trying to create a 10-acre block of land that would encompass the land needed for the farm operations, but also accommodate that open discharge system. A few other wrinkles along the way in this one. I'm going to try to highlight them using this particular diagram. So it's a little faint, but you can see the pink outline around the boundaries. That is the original 10-acre block of land, and there's talk that depending on where the relocated discharge point for the open discharge system would be, that may have to extend a little bit to the south to make up the distance and separate from various facilities. However, we probably forgot to take into consideration one of our conditions that may give the applicant a little bit more flexibility on how to do that. So nonetheless, it may actually stay at 10 acres because the open discharge that you can see The existing one is with the blue lines and the yellow dot. And then you see a kind of a faint kind of tan one with a triangle where we show a proposed relocation. And one of the items we were trying to dodge was the green dot, which is the existing well. But in the course of getting the approval from Alberta Environment and Parks and Alberta Health Services for the setback relaxation from landfill, they've asked that the green dot, which is the well, be completely capped and decommissioned. Even though it's still used for livestock, it's not used for human consumption. But the concern from the health perspective is that that would be a weak spot or an opportunity for the groundwater to be polluted or contaminated, and then have a potential harm for others that are using the local groundwater sources that are potable water supply. So with that green dot decommission, there may be more flexibility than what we're showing on this drawing for that relocated open discharge point. So it could slide a little further to the north and shorten up the parcel if the applicant's interested in reducing their rural development fund contribution. What's not shown on the drawing is the interesting one that came up that's mentioned in the report. It was in the course of doing the site inspection, we found yet another open discharge. And that is for the nice steel building that you can see in the very top of the air photo, where there's a nicely developed internal shop that has its own washer facility. And when you go off to the east, it had its own discharge point. So the applicant doesn't know about that. We put in the condition there that's a range of options. They could decommission that. That was take out the bathroom from the shop. That's one way. Or they can link that one to the main discharge point for the house. That's possible. So we tried to set that up as well. But the relaxation from the from the landfill does come with some conditions. The expectation is that no development within the original 300-meter distance, so that would be within a good portion of the north part of the parcel. Be allowed that has any basement that goes into the groundwater table. And usually the biggest issue for development coming close to a former landfill or an existing waste transfer site is the possibility of any leachate underneath that would come into human contact. And that's either that it's going to be accumulating in an open space like a basement where people may inhale it or come into physical contact with it, or contaminate their groundwater supply that they use for domestic purposes. That is a little bit unique in this case, in that this particular site is served by the regional water line coming down from the village of Botha, so it's not using a private well for the humans. The well at the green dot is only used for livestock purposes. Nonetheless, that I've already mentioned that the desire to have that decommissioned to protect the groundwater for others. So that is, the last thing I do want to point out, Mr. Chair, is the new access approach that AT had approved onto Highway 850 had already been constructed. You can see that in the photos, but it hadn't been finally inspected and signed off. And the applicant is aware that if they have to, they may end up moving that further depending on where they choose that final parcel boundary to be. And that should fit within their existing roadside development permit with AT, but if it does not, they'll have to go back to AT and obtain a revised roadside development permit and basically obtain their permission for direct access onto the highway. So with that, just want to briefly go over some of the conditions again. If we could jump to page 49, please. And the first two always being, well, the first three being the pretty standard ones. The second two, 4A and 4B, top of one page, scrolling down to the second. And actually in this particular case, we are going to a 4C. That's for the existing open discharge that we knew about for the house. So there's a range of options there on how that can be satisfied, but still with the intent of meeting the property setbacks for the open discharge within the new parcel being created. Number 5 touches on the one that we found in the field. It has a range of conditions as well. And number 6 talks about the approach following the roadside development permit approved by Alberta Transportation. And 7 is a restrictive covenant that flows from the AEP requirement. That's basically a note that will go on title to alert future property owners that a relaxation has been given, that there are conditions in terms of no basement development within a certain distance to be able to follow through on the commitments or the expectations for the AEP approval. And number 8 also links back to the AEP and AHS comments on that in terms of confirmation that the water well, the green dot, has been properly decommissioned and capped. With that, Mr. Chair, I'd be happy to field any questions.
Okay, on 2 questions I have quickly. Is the applicant okay with decommissioning that water well? Have you spoke to them?
Not personally,
Okay.
So I can't speak to whether or not that is.
For the stage, it'll be kind of a take it or leave it because it's coming directly from the provincial regulator.
Who would sign off on that it is done?
Ultimately, all the conditions you see are signed off by county staff on whether or not they're acceptable and meet the intent of the condition. So if that comes in, we would have to, I guess we have to provide a lot of detail on how that would be done. I would probably accept, if you brought in pictures or confirmation from a contractor that, we cut it, we capped it, or cemented it, I'd be prepared to accept that.
And I get,
That would also have to be filed, I think, with, for the well licenses
okay,
or environment,
Yeah, it should be in terms of.
from a certified well company.
that's what I was wondering, if you would have to have like a well drilling company come in and do that. That's what I thought. They zonulite it or something, don't they? Or tonight, that's right. And the remainder of the quarter access, you had mentioned about it, but I'm not seeing it anywhere on our picture where.
Yes, so that would be the south one. The south property line, you already had it built in place. Maybe we could jump to one of the same photos, we can actually see that.
I just don't see it anywhere. That's why I'm wondering.
Yeah, on the air photo, it wouldn't appear because he literally had none existed. So if we jump to the actual site inspection photos, sorry, Android.
Okay, fair enough.
There you go, that's excellent. So that had been put in, and as we mentioned, had not yet been inspected, and depending on where their final property line, that may have to be dug up and relocated farther south.
Okay, and no culvert in there?
Well, that's between him and AT, but I don't see a culvert in there.
There's a 400 culvert. Did you feel that?
Mr. Gender, I'm going to ask you to step out on this one, please, as conflict of interest. And please, in the future, let us know that that's the situation.
On the photo, Mr. Chair, my mistake, it's kind of a little bit of snow on either side, but you can't see the white circular. And it's easy one to set this aside, given that it's AT's issue.
Yes, no, fair enough. Any questions or concerns, Mr. Stevens?
Just a clarification, that well that needs to be capped off, that isn't their only water source? They have another well on the property, or?
Don't, for their own domestic needs, they actually have the benefit of a water line coming down from the village of Bath, and they're fed on that system.
Perfect.
I thought that's what they had there.
Compelling part of why AEP, I think, provided the relaxation in this specific case.
I'll move it forward with the recommendations.
The conditions, of course, being the new conditions of the well.
Yeah, be all enforced or as part of the.
And then the option that they have the opportunity possibly to change the now, move that discharge to a different location. Okay, is everybody good with what we've got? Marlene, you're good? What's that? As in with the new conditions that I think were put in place, that we got the report from AP saying that they had to decommission,
Decommission, thank you. Mr. Chair.
That actually is in the report as condition number 8. So,
Okay, then it is, yeah. The way you proposed it, I was thinking it was new. Fair enough. Okay. All those in favor? Well, that's carried. Okay. And we've done 7.2, new business, 8.1.
Thank you, Mr. Chairman. We have received a referral from the Summer Village of Roshan Sands regarding subdivision of a 2-acre parcel from the southwest of 1940-28. And that's the location it's proposed for the water fill station. They're also proposing to amend our land use bylaw to add public utilities as a permitted use in the reserve for future development land use district. So there is a map showing the location of the subdivision as well as the rezoning of that parcel to the, not the, yeah, the rezoning. No, I went to 100% here. And Tech prepared this map showing the location.
Any questions, concerns that we've got here? I keep seeing Andrew Grushick's name on it. Any questions, concerns? And can I get a motion to move this forward? Mr. Clark? Okay. All those in favor? That's carried. Referral, Town of Stettler, 8.2.
Thank you, Mr. Chairman. This is also a proposal for a subdivision in the town of Stettler. Sorry, I'm just going to get this location here. It's 16.33 acre parcel, and they want to divide it into two parcels, one of 10.96 acres and a 5.37 acres. It's within a residential, commercial, and industrial uses in that area. And then there is a map showing the location, which is just on the east end of town near the train station, Alberta Prairie train station. In that vicinity.
It's in a referral area? It's got to be right on the edge, isn't it?
Well, it's in the town, so it's just, yeah.
Yeah, the seed cleaning plant would be across.
Yeah, no, I'm just, I mean, it's almost like, I thought downtown was almost not in the referral area.
We could get most of the referrals regardless of the location, so.
Okay, any questions, concerns? Mr. Gender?
Kind of wondering whether we should ask them, okay, being that we've been kind of held back on our sewage with them. What are their plans on doing with this sewage if they've reached that threshold?
Okay. I think that's very proper. We could send a letter asking the plans for the sewer on this if they haven't already determined that or told us what they're doing. I don't think they have. I doubt they can use open.
That old, that
You'd have to,
50 acres probably could.
Yeah, but now they can't.
Count, yeah.
And I don't, is that serviced over there? I'm not sure where it's serviced.
I would think it is. It's right in the town. I mean,
Is the seed cleaning plant service? Councilor Rowe? It is?
It's got sewer service, or does it just?
There is actually sewer service Force Main along the south side, right along their boundary.
Okay. Yeah. So we'll ask the question and they can tell us that's what they're gonna do is hook it up.
Well, especially with that big body of water and that larger parcel too, you're supposed to be so far away from that too. So.
Sea drain plant does have a washing downstairs that you can use that, so.
Yeah, but it is hooked to it's hooked to the town system.
I don't know that.
Yeah, no, that's what we're asking.
I don't know either.
I don't know for sure that.
Yeah.
They got sewer, yeah.
But Mr. Gender, you figure there's a force main on the south side, on the seed cleaning plant side.
It goes on the north side of that street in front of the seed cleaning plant all the way down to the P&H.
Okay.
On the north side, so south side of the property.
Yes.
Okay.
Okay. Mr. Stevens, you had a question? Nope. So
We're gonna ask them about that.
we're gonna have instruct administration to get clarification on the sewer system, how that's gonna work, and then any other questions or concerns? So I guess we'll receive that for information at this point then. Mr. Grover, all those in favor?
Information.
Old business? None? We got anything you putting us in camera for?
no, I don't think unless Craig had some.
Okay, we have one last thing to do. Jacinta, this is your last meeting with us. It's hard to believe. It
He's
is.
had enough of us.
I don't blame you. But I do blame you for leaving us. I totally understand. So, on behalf of the MPC and the county, we have a gift for you. It's very minute compared to the service you gave us, but it's the thought, right?
Don't break the camera.
I'm allowed to give you a hug.
There. Thank you for being a friend.
Thank you very
so
much.
And thank you. It's been a pleasure working with all of you. I just enjoyed this last 18 years. It's been phenomenal, really. So I'm leaving with mixed emotions, but I think it's the right time to move on and have some new blood. So that's what's going to
So
happen.
after the meeting, we're going to go back into the other room and we're going to have some cheesecake for our coffee breaks. Thank you very much. And with that, the next meeting will be the 23rd. Is that right? We're good to go on the 23rd?
Okay, I need a motion. Mr. Stevens, motion for adjournment.
All those in favor? Carried. Thank you.